Tune in to Georgia Wednesdays on KSCO Presents from 12 to 2 for the freshest conservative voice to come along in years. Born and raised in South Carolina, Georgia has a sweet southern charm backed up with the tenacity of a junkyard dog as she speaks her mind about the direction of our country and the elected leaders responsible for that direction. So make it a date for lunch with KSCO Presents Georgia every Wednesday from 12 noon to 2 p.m. on your Listen and Be Heard radio station, AM 1080. KSCO. And now, KSCO presents Georgia. If you'd like to participate in our program today, give us a call at area code 831-479-1080. That's 479-1080. And now, KSCO presents Georgia.
Good afternoon and welcome to KSCO 1080 AM. My name is Georgia and I am your host for KSCO Presents. It is Wednesday, April 10th, and I welcome and thank all of you who are listening to us on the dial or streaming us live on KSCO.com. And hello to my trusty favorite engineer, Sam Quinton. Hi, Sam.
How are you doing today, Georgia?
I'm good because we have a fabulous show today, Sam.
I'm raring to go for this one.
Yeah, this is a good show today, Sam.
You bet.
Okay, so we are very proud to be a part of one of the last bastions of an independently owned radio station, thanks to the Swirling family. This allows those of us who are dedicated to try to sort out the truth and report news, opinions, and have discussions that you are not likely to hear through the mainstream media. The mainstream media appears to be asleep at the wheel. A free investigative press is one of the pillars of a healthy democracy. However, if the paid professionals are not going to do their jobs, that task falls to those who are interested in investigating, asking the questions in pursuit of the truth. Shedding light is the best disinfectant, and that is what we will attempt to do today. I think this is one of the most interesting, complicated, and disturbing stories of the decade, and I am delighted to be able to share it with our listeners. Now, Facebook is one of the most recognizable names today. This story may change Facebook as we know it. A court has decided that Facebook infringed on 11 of 11 claims of a patent filed by my guest, Mike McKibben, the CEO and founder of Leader Technologies. Mr. McKibben says this patent is the foundation of Facebook, the source code. It is what runs the engine of Facebook. So, is Facebook the evil twin of Leader Technologies? Oh, what a tangled web we weave when we first practice to deceive. Welcome to KSCO,
it's time
Mike.
to turn on the lights in the kitchen and watch the cockroaches scurry.
That's right, Sam. Hi, Mike.
Hi, Georgia. How are you?
I'm great. Welcome to KSCO, and thank you so much for being here with us today.
You're welcome.
Mike, this is a fantastically interesting and complicated story, so we're going to try to explain it to the listeners in a simplified way if we can. This is your case against Mark Zuckerberg and Facebook, right?
That's correct. Against Facebook specifically.
Right, exactly. So, Mike, why don't we start? What I want to do today is go back in time, if we can, and take this in chronological order so that the listeners can understand the events, when and how they occurred. And I'm going to ask my listeners, who are wonderful callers, to hold off on your calls until you've heard the story. And then we will open up the lines to hear what you have to say. And I know you'll have something to say, either comments, questions, whatever. But let's let Mike's story be told before we start opening up the phone line. So how does that sound, Mike?
That sounds good.
Okay, so let's go back, Mike, to 1997 when you founded Leader Technologies in Columbus, Ohio. You at that time said there were only 10 million people using the Internet, right?
That's approximately the number, yes.
Yeah. So you saw an opportunity here, right, Mike? And you want to tell us about that?
I did. In the mid-'90s, in a prior company that I had the opportunity to assist AT&T in rebuilding their email system. Mm-hmm. And this was, if you recall, back when Microsoft first announced Windows 95, this was a system that AT&T needed to run their email system on the Windows platform. So we worked closely with Bell Labs and built that. Mm-hmm. And I left that company and said, there's got to be a better way to do this. And had an idea that at that time, you'll also recall there were these browser wars between Netscape and Internet Explorer. So there was a lot of foment around how the Internet was going to develop. But in the midst of that, I had some specific ideas for how we could use this emerging Internet technology to collaborate better on a large scale. And I had supported many of the large-scale operations within AT&T and with key customers with my company. So essentially in '97, I formed Leader Technologies to research and develop a program or an application that would use this emerging Internet technology to help people better collaborate. At that time, there was no sense of a name called social networking. I focused on leadership issues as one of the primary objectives of organizations to how they could better lead their organizations. So I put together a team of developers, which I would put up against anybody in the country. And we essentially went underground and we said, we're not coming out until we figure out what's wrong with large-scale collaboration. And we specifically want to focus it on the emerging Internet. Well, this was before Google. This was back when there were less than 10 million users. And so obviously it was not the time to introduce the product at that point. So we were inventing.
Mm-hmm. Go ahead. I was going to say security and privacy was one of your main important goals, wasn't it, Mike?
Well, absolutely. When you've got any kind of large-scale platform, security and privacy issues are front and center for any organization and any individual. So those were two bedrock design criteria that we worked on embedding into this invention, which the public knows part of it now, called social networking, but it was much larger than that at the time. Mm-hmm. And so we knuckled down. We raised our own money. We started writing code. We started doing research, and that took a number of years. So we did that all the way through the 2000s into 2002. And when we felt like we had the code in good shape, we decided to file for patents because at that point it was still early days for any kind of commercial exploitation. Mm-hmm. And so that's what we did, and we sought experts in Washington who were experts at trade secrets and patents and copyrights, and we asked them to assist us in properly protecting our technology through the patenting process.
Now, Mike, when you file a patent, which you did in 2002, how long is that patent protected before it becomes published? Is it protected till publishing, or how does that work for those of us who don't know?
The clock on the date starts when you file the patent.
Okay.
And there's 20 years from the time you file.
Oh, all right.
So the time it takes for the patent office to get through the patent counts against your 20 years. Mm-hmm. The patent office will often give you some of that time back depending on whether they were slow or whatever. So sometimes you get awarded additional time, but it's a 20-year time frame for the monopoly that the U.S. government gives you on a new invention.
Okay, because that's an important piece of this puzzle, isn't it?
Right.
Okay, so now, Mike, you say that it took 145,000 man-hours and a $10 million investment to create the technology that we're talking about here today with Facebook. Is that correct?
That's correct.
And Mr. Zuckerberg claims he did it in 2 weeks while studying for finals at Harvard. Now, Mike, how realistic is that?
Well, that's been one of the great puzzles in the Facebook story all these years. Why the media has not asked this question? That has come up several times, and I think the main reason is because most people don't understand how software development works. So they wouldn't know whether that's possible, that's credible, or whether he's just a very fast programmer. Nobody would know these things.
Or a genius.
Or a genius,
yeah.
But even a genius can't write code that fast.
Mm-hmm. Yeah, very interesting.
The average programmer, maybe 2 to 1,000 lines of code a day. Well, our code had over 500,000 lines of code in it.
Mm.
So the idea that somebody, while they're attending school, could build a large-scale platform that could go public on February 4th, 2003, from a development standpoint, is just not a credible story. But, again, the general public wouldn't know whether it's credible or not. So I understand why that's never really been scrutinized.
Yes. Okay, now, Mike, in 2003, you issued technical white papers. Tell the listeners what white papers are.
Okay. When you're filing for a patent, one of your obligations in filing for your patent, as soon as you've filed for it, you're supposed to start describing your technology so that the public can benefit.
Uh-huh.
And so one of the ways you can do that with technology, which people can't necessarily kick and touch and feel, is you write about it. And so one of the ways you write about that in software development is you write white papers, which are basically technical descriptions, high-level technical descriptions of what it is your software is doing, who it benefits, how it's built, those kinds of things.
Okay.
So you get into details.
Okay, so that was the details of the work that you had done with the 145,000 hours, right?
That's right.
Okay, now here's where it gets very interesting, folks. That was done in 2003. The white papers were issued. Now, Mike McKibben emailed the technical white paper to his son at Harvard on October 22nd, 2003. His son was a student adjacent to Mark Zuckerberg's dorm. Am I correct, Mike? Your son was there on campus.
That's right.
At the same time.
They were in the dorms next to each other.
Okay.
Kirkland House and Winthrop House.
Okay. Did they know each other, Mike? Either one of the boys, or did Mark Zuckerberg know of Leader Technology at that point?
Well, I can't speak to what Mr. Zuckerberg did or didn't know, but I've asked my son that, and he was generally aware. Harvard isn't a big campus, and especially when people are going to and from classes. So he was aware of some of the actors in the Facebook story. He doesn't recall knowing Zuckerberg, but there was a general awareness of who he was.
Okay.
Because he was in that dorm a lot.
Okay. All right. So now we get to the infamous hacking that occurred on October 28th in 2003. Right?
That is information that was made public in the Winklevoss twin case, the ConnectU case, a number of years ago. So we've been able to see Mark Zuckerberg's deposition and also an online diary describing that event, yes.
Okay. Were you aware that your white paper had been hacked at that time, or when did you find out?
Oh, we weren't aware of that. We weren't aware of Facebook. We weren't aware of Zuckerberg or anything like that.
Okay.
This has all come out many, many, many years later.
All right. All right, now we move to Leader conducts confidential beta tests with several firms, including clients of Accel Partners, throughout October of 2003. Is that Jim Breyer? Who is Accel Partners?
Well, Accel Partners is in Palo Alto, and
okay.
I believe Jim Breyer is the managing director or managing partner.
Okay, because he becomes a huge investor in Facebook, right?
Yes, that's very public.
Okay. All right, so Facebook is launched in February of 2004. Leader's patent application publishes in June of 2004.
Right.
So let's pick it up there.
Well, hindsight's much more
2020.
informative than that. At the time, we weren't aware at all of anything that Facebook was doing. In fact, I think maybe my son had mentioned something to me about something he had seen. I don't recall that specifically, but one of the things we discovered as we were looking back at the facts of that time is there seemed to be coincidence after coincidence after coincidence of an event in Leader and a parallel event in Facebook. And it, to a mathematician, that starts to get, you see patterns.
Mm-hmm.
And we then started looking at the functionality in the first version of Facebook, and lo and behold, it was exactly the same functionality as was described in the white paper.
Very interesting.
We then start looking at when our technology was published, and magically that same month, Facebook, and this is very public information, adds the groups functionality at the very time when our groups functionality was disclosed in the first publishing of our patent.
Yeah, that was in July of 2004, right?
Right.
Mm-hmm.
So as we've marched down through this calendar, it became more than just uncanny. It became a situation where mathematically it's more likely that yours and my DNA matches than he didn't copy our technology.
Wow.
So that was our first real suspicion that something was amiss here.
Yeah. Mike, we're going to have to take a quick commercial break. If you will stay with me, and listeners, stay with us, we will be back to continue this story. Welcome back, everybody, and thanks for staying tuned in today. We are talking about the Leader versus Facebook case with Mike McKibben, the CEO of Leader Technology. Mike, are you still with me? Mike, are you there?
Yes, I'm here.
Oh, okay, good. So let's pick up the story. So, Mike, Facebook is launched in February of 2004. Leader's patent application publishes in June of 2004. We see that Jim Breyer invests $12.5 million in Facebook. Then Leader's patent is awarded in November of 2006. Correct?
That's correct.
Okay.
That's correct.
Now, you then file patent infringement lawsuit against Facebook in November of 2008.
That's correct.
Okay. So that's when it began.
That's when the Leader v. Facebook case began, yes.
Okay. And your trial began on July 19th of 2010. Now, this is a very, very interesting trial, Mike, and why don't you tell us about the verdict?
The verdict was a surprise.
Mm-hmm.
It was a split verdict. There are a number of things about the case that, looking back, were odd. One of them was the way the case was split up, and we only did part of the trial. We only did the infringement portion of the trial. We didn't do the damages, the willful infringement, and the injunction part of the trial. The judge split those off and said, we'll do those later if we find infringement.
Okay.
So we did the infringement portion of the trial, and we received a split verdict in that Facebook was guilty on 11 of 11 counts, as you said earlier, of literally infringing our patent, which is the highest form of infringement. There was also a decision that there was no prior art, contrary to the great hue and cry out in the blogosphere that we were patent trolls and things like this.
Yes.
Facebook and their friends were unable to put up even one piece of prior art that would otherwise knock our patent claims out. And then the part of the trial that went against us was something called on sale bar. And this is the very obscure law that deals with the fact that you're not allowed as a patent, somebody who's developing a patent, you're not allowed to start selling your patent more than a year before you file for the patent, roughly speaking. There's some nuances there.
Okay.
But basically, that's the concept. And the jury decided that we had tried to sell it too soon. And this was a surprise to our attorneys, since Facebook didn't even put up an expert witness on that subject. They were completely relying on several pieces of doctored evidence, and they convinced the jury somehow to rule against us on that piece. And that's called an invalidity verdict, which technically invalidates the claim in the patent trial for those particular claims in our patent against Facebook. It doesn't invalidate your patent for other infringers, but it does for that trial. So we appealed that. And then the appeal process then is where we encountered an enormous amount of misconduct. But that's how the patent went. So it was a split decision.
Okay, but within that on-sale bar issue, wasn't some of the jurors' information redacted?
Yeah, there were two pieces of evidence the judge said were the basis of the on-sale bar verdict, in his opinion. And one of them was something called interrogatory number 9. And interrogatories, it's a fancy name for, they put before a trial, you get a set of questions and you answer them.
Right.
You're interrogated. And so we had answered a set of questions related to our technology in 2009, which was the basis of the question. We were ordered by the judge to answer in the present tense for what was the nature of our product in 2009. When Facebook presented that information to the jury, they actually literally blocked out about 60% of that interrogatory, and that's what was shown to the jury.
Wow, Mike, isn't that jury tampering?
Well, you can call it whatever you want.
Well, I mean, it seems to me that would be a mistrial when you tamper with jury information. I don't know how they were able to get away with that. Do you?
The judge approved it.
The judge approved it.
Our attorneys objected and asked that the whole interrogatory be shown, and the judge overruled it and allowed Facebook to present just the doctored pieces.
My goodness.
So that was one of the two pieces. And then the other piece was a really small snippet of my 2 days of videotaped testimony where I was answering questions about our product, and Facebook took a section of it out of context, and then the judge said the combination of those two pieces of evidence constituted clear and convincing evidence that we had tried to sell it too soon.
My goodness.
And again, they did. That was the basis of the evidence. There was no expert testimony. There was no third-party testimony. There was no engineer testimony. No nothing. We weren't allowed to go out and interview the people that we allegedly tried to sell it to, and that was another anomaly in this trial. The judge that actually heard the case at trial was not the judge in this case until 3 months before trial.
Right. There was an original, judge, right.
And we had a 25-plus year judge, Judge Farnan, before that, and then for some reason he decides 3 months before the trial to resign and retire, and then Judge Stark comes in. And this was after the close of discovery. Now, maybe people who are not familiar with litigation don't know what discovery is, but discovery is where you ask the other side to give evidence and you give evidence. And so essentially the idea of a just trial is you're supposed to have all the facts there so that when you put those facts before the jury, they can make a fair decision. That's the principle, and that's the role of discovery. Well, after Judge Stark came on this case, Facebook changed their claims and added this on-sale bar claim after the close of discovery. So when that happened, we wanted additional discovery, and the judge blocked that. We were not allowed to do any more discovery to prepare our defenses for this new accusation.
My goodness. Well, Mike,
So that's why there was no other evidence. There was no expert.
Yeah. We'll get to those judges in a moment, but I'm trying to stick with the chronological order here, and I hope people are understanding what we're saying here. Facebook then files an S-1 public offering disclosure, and in doing that, there was no mention of the trial or impending appeals or anything. They just completely didn't mention it.
That's right.
That's a very interesting thing, don't you believe? That they wouldn't have to mention that with all of this going on?
Well, I can tell you that numerous securities people that I know think it's unusual not to disclose something like that, but there are lots of ways to finesse wording in a disclosure, and I guess they felt like they had done what they needed to do.
Mm-hmm. Okay, so now you get this... You are going to appeal this, correct? This decision that was made, you guys decided to appeal it.
Yes.
Okay, tell us the story about the only news show that did carry the story, which was Fox News Business, and what occurred during that interview there. While you were in the appealing process, you thought.
Well, when you appeal a patent case, unlike appeals in other jurisdictions, all patent cases at the federal level are appealed to the Federal Circuit, which is a special court in Washington, D.C. that handles all patent trials, appeals on all patent trials. So we appealed to the Federal Circuit. And that appeal was denied. In other words, they did not overturn the jury. We argued that, hey, this interrogatory and this piece of snippet of testimony does not constitute clear and convincing evidence. They said it does. And so then we got that decision, and then we appealed for a rehearing, which is the next step.
Okay.
So you basically say, come on, look at this again. And so while that rehearing was pending, a decision on the rehearing was pending, I got contacted by Fox Business to do a live interview on national television, which was something that I did like a week later. So in the interview, I was informed by Shabani Joshi, the interviewer, that our appeal for rehearing was denied.
Wow.
Now, this was 3 days before our own attorneys got notice that it had been denied.
How can that be, Mike? How would they know before your attorneys or you were notified?
Well, when I asked them that, they said we don't disclose our news gathering sources.
My goodness. This is very, very, very interesting. So that's where it stands. Am I right? Or did the Supreme Court deny the hearing? That is what they did. That's where you stand now. Is that correct?
Well, that rehearing was to the Federal Circuit.
Okay.
We then filed what's called a writ of certiorari, which is basically appeal to the Supreme Court that gets hundreds of those in every grouping that they consider. They chose not to hear the case. So that's where it stands right now.
Mm-hmm. So they chose not to hear it. Something of this magnitude, they chose not to hear it.
Right.
And they can just do that.
Yes.
Yeah. Okay, then let's get a little bit of information of what you found out about the federal court judges and their perhaps having some kind of a connection to Facebook with owning tremendous amounts of shares of Facebook stock. A little bit of a conflict of interest, I would think. But you want to tell us what you discovered?
Well, I have several hundred shareholders, and these people are not unsophisticated.
Mm-hmm.
And one of my responsibilities is to advocate for their position. I mean, these people took real risk back in the late 90s to support us, to put in that $10 million to invest, to get those 145,000 man hours, to invent what obviously is a very valuable piece of technology.
Mm-hmm.
I have got a group of hundreds of people who are fit to be tied by the treatment that we're getting in the justice system. So I had numerous ones of them start digging on their own because they smelled a rat.
Mm-hmm.
And lo and behold, this new information started occurring, and the first place that this emerged was from the judicial financial disclosures, which every federal judge is required to submit every year, that discloses their financial holdings.
Mm-hmm.
And lo and behold, on several of the judges' reports were holdings in funds that were well-publicized major shareholders in Facebook prior to the IPO.
My goodness. And that was all three of the judges, correct?
To my knowledge,
Mm-hmm.
2 of the 3.
Okay, 2 of the 3.
But others have asked that the judges disclose their financial holdings, and the rules are that a judge and the extended family cannot hold stock in a company that the judge is hearing. That's the rule with the Code of Conduct.
Mm-hmm.
When the judges were asked to disclose their Facebook holdings, they refused to reply.
And they can just get away with doing that, Mike?
You know what? I'm not sure anybody understands the answer to that question.
I mean, this is almost like a Hollywood movie. That this is occurring in our country, because really what is frightening to me, Mike, as an American citizen, is this whole issue of property rights. This was your intellectual property. But if they can take that away from you, what is the next property right that we are all vulnerable for? In other words, we're all in this game here. And
Exactly.
If you cannot trust the judicial system, who do you trust?
Well, you mentioned property rights.
Mm-hmm.
Well, a lot of people don't understand exactly what a patent is, so maybe a little example would help.
Okay.
A patent is an intellectual property right. In other words, I've described something in words for something that might or might not be physical. And with software, it's just people know the results of software because they can see it on a screen, but they don't know what's going on behind the scenes.
Mm-hmm.
But I call those the gears and the pulleys of software. So software can be described just as clearly as if I've got an invention with a bunch of gears and pulleys behind the cover.
Mm-hmm.
And so a patent is very similar to a deed to or a title to your property. You know, when you buy a piece of land, you do a survey, and they lay out the borders of that land, and then if you've properly purchased that, you hold the title to that property. That's your property.
Mm-hmm.
And so a deed, in a sense, is a title to an idea that is unique, and that the government has said is unique and is willing to let you have a 20-year monopoly on that idea to encourage more inventors to publish more of these ideas so the public can benefit.
Right.
So when you need to protect your property, essentially what happened is Facebook parked right in the middle of our property on our land.
Mm-hmm.
And started using it.
Yeah. Mm.
And so we went to the courts to say, hey, they're using our property, and these courts just turned a blind eye.
My gosh. Well, that explains it on a level I think that we can all relate to, Mike. Thank you for that. I'm going to have to take another quick break. We will pick up the conversation when we come back. Stay with us, folks. Welcome back, everybody. We are speaking to Mike McKibben, the CEO of Leader Technologies, in the case of Leader versus Facebook. And we have been talking about the events and how they unfolded. We left with the issue of property rights, which I believe every one of us should really pay attention to this and be very, very concerned about this, because this affects all of us. Now, Mike, let's bring in some of the other players, because what I want to do is try to get the story done in the first hour so we can open up the calls in the second hour and see how people are responding to this amazing story.
Okay.
And let's start with Larry Summers, who was president of Harvard while Mark Zuckerberg was a student there. He was Obama's top economic advisor, and he was a former U.S. Treasury Secretary. And I think Obama appointed him head of the World Bank. Is that correct?
I believe that's what the World Bank records indicate, yes.
Okay, so tell us how Larry Summers fits into this piece of the puzzle. And I guess we must then talk about the Goldman Sachs $32 billion bailout. I guess we have to bring that in, don't we? It's part of this whole story.
Well, I mean, people are. I mean, there's a number of people that have been investigating the various connections behind the story, and every time they follow another trail, it opens up a new area. So the involvement of the people who made Facebook possible is quite a complex story.
Mm-hmm. Okay, so Larry Summers is at Harvard. He, according to what I've read, handpicks Mark Zuckerberg, cherry picks him out for this.
Well, some people have said that. I actually met him at senior day. My son played football at Harvard,
mm-hmm.
And we met and shook hands briefly. But the other aspects of his involvement with Facebook, I think, are just emerging now. So I think there's a number of reporters that are digging into that now.
Good. Now, at the time of this bailout, Yuri Milner was partnered with Goldman Sachs, and they received at least $16 billion of U.S. taxpayer funds. And he reappeared 6 months later with bags full of money totaling $3 billion in overseas funds to purchase Facebook insider stock. Something's a little, it's starting to get a little bit rotten here. Something is rotten in Denmark here, Mike.
There was a lot of coverage of his emergence on the scene out there your way.
Mm-hmm.
So I think a lot of people were surprised and wondered what the heck's going on. How did all of a sudden a Russian company get involved with Facebook, and where'd that come from? And I know a number of reporters have been digging into that and discovered a World Bank connection to both him and Sheryl Sandberg, who's the chief operating officer of Facebook right now.
Yeah. She was on 60 Minutes about a couple of months ago. The big story of the night was Sheryl Sandberg, who is the chief operating officer at Facebook, is the new model for women. She is one of the richest women in the world, and she's a player in this as well. So
most definitely.
We've got Summers, we've got Sandberg, we've got Yuri Milner, we've got who else? There's quite a list of players here that seem to have an investment in this whole Facebook phenomenon.
Well, the Facebook story has morphed and evolved and changes, and now we learn that some of the key players in LinkedIn were involved with Zuckerberg, even going back to his Harvard days, specifically Reid Hoffman, and who is the CEO of LinkedIn now.
Mm-hmm.
And then there's Peter Thiel.
Yes.
Thiel. I'm not sure how you pronounce it.
Thiel. Peter Thiel.
Right. So he was a financier during that first summer, and that's well known, well publicized. He financed Mr. Zuckerberg with $500,000, and I've spent my life raising money and talking to venture capitalists, or my business life anyway, and either this guy is one genius at raising money and relationships, or something else was going on, because he has lived one blessed life ever since he left the Harvard campus.
Mm-hmm.
And I've talked to many entrepreneurs, and they say, I don't see how that's possible unless there's another story undercurrent here, and that appears to be what's going on.
Well, it's interesting, this connection to Russia. I think that's a very interesting piece of the puzzle here, and they're owning so much of this Facebook stock.
Right.
Also, my understanding, as of April 1, 2013, patent offices cites presidential privilege to block a Leader versus Facebook Freedom of Act.
Right.
Information Act. What in the world? How is our president now involved in this scheme of things, Mike?
I have no idea. But one of our more irate shareholders filed for a Freedom of Information Act request from the Patent Office to find out what's going on, because there's certain things occurring at the Patent Office to try to continue to try to invalidate our patent that our patent prosecutors, that's what you call somebody who files a patent for you, have never seen in their careers, and these are some of the most experienced people in the country. And so these particular shareholders started inquiring, and every time they asked questions, they received more vague responses, obfuscation, and then his last request came back with this appeal to a presidential privilege, and we go, what?
Mm-hmm.
It was very surprising.
Yeah. Although President Obama, I think part of his ability to win his elections were contributed to the technology of Facebook. I think that's how I think he's got 35 million Facebook followers.
Well, every demographic person in the country involved with politics knows that that's true.
Yeah. So now we have all the way up through the judicial branch to the executive branch some real question marks as to how all of this makes any sense to what happened to you with your patent.
Right.
And there are no easy, good answers, Mike. Except something feels very wrong here.
At this stage, the best thing that can be done is to put the facts out there, and people are going to have to draw their own conclusions as to what they mean.
Yeah.
And that's what our supporters are working to do, is get the facts out there.
Yeah. But you haven't been able to get this anywhere where the majority of the people in the country can hear it. They can hear the facts, right? They're just not covering this story as though they're not covering many of the stories in this country today.
Well, I can't count anymore the number of people who call here and say, I can't believe I'm not hearing about this case in the mainstream media.
Right.
And at this stage, we just sort of make a joke about it, that it's all we hear are crickets.
Mm-hmm. Yeah.
Whenever this subject comes up.
Well, it seems to be the way it is today with the media, and it's very disturbing to many of us because there are a lot of stories that aren't being talked about that we feel are very important, yours being one of them. So all I can say is it's a very, very interesting story, and it isn't over yet. I'm sure you have a game plan. I know you won't share that plan with us, and I don't blame you, but I hope it will be successful, whatever it is that you endeavor to do going forward, because this is really awful.
Well, we're Americans, and we try to rely on a just system. Mm-hmm. And the thing that's not happening right now is we're not seeing our courts apply the law fairly. Mm-hmm. And that's all we ask for, is a fair shot.
Right.
And everything about this case, from the end of the trial through the appeals, has been judges looking the other way and ignoring things and decisions that they've made hundreds of times, maybe not hundreds, but 10, 20, 30 times in other cases. And we're finding in each case, our case becomes an outlier for what they normally do. So after a while, you start putting the pieces together and you realize there's another agenda here.
Mm-hmm. Yeah, very, very, very obvious. And I hope that in time you will be able to get to the bottom of it. I really do.
Well, we're hoping that those that know what's going on in their various capacities will believe at some point that maybe their personal self-interest and, maybe they've received a good payout is not as important as supporting a sound justice system in this country.
Yes. Gosh, without that, what do we have? I mean, we're all so vulnerable. We're all at risk.
Well, business can't conduct itself if there's shifting sand underneath. If there's no foundation to fair contracts, fair patents, fair property rights, then business deteriorates because entrepreneurs and business people have to spend all their time dealing with regulation and breaches of lawyers and things like this instead of producing something.
Yes. Well, Mike, I'm going to have you hold right there. We're almost at the top of the hour, and we will pick this up with your calls when we come back. Welcome back to the second hour of KSCO Presents. We have just heard from Mr. Mike McKibben, the CEO and founder of Leader Technology, about the Leader versus Facebook case. Now, our phone lines are open to you now. Our number is 831-479-1080, or you can email me at georgia@ksco.com with questions. We have some callers on board, but there are some open lines. So I hope you will call in and give us your opinion on what you've heard here today. And let's go out to, Mike, are you with me?
I'm there.
Okay, we're going to go out to Annalise in SoCal. Hi, Annalise. Welcome in, and you have a question.
Yes, I do. Thank you, Georgia, for taking up this very interesting case. It's been in the paper, and it's been a little obscure to try to follow from what is and is not reported. Hearing it from Mike's perspective, it really becomes quite curious how this case was ever heard in the court in the way that it was, even from the beginning, when the interrogatories were not all presented at the time of discovery for Mike's attorneys to review. That automatically invalidates the case because you can't bring forth evidence that was not put forth in discovery. How did that happen?
Yeah.
And all the way through, as I'm listening to it, I'm thinking, this sounds like corruption. And for me, I look at follow the money. My husband was involved in a lot of court cases, so that was, how I heard about a lot of court cases, and often it just goes back to follow the money. And when it got into international money, when you have Yuri Milner, Russian, involved in this, and the World Bank involved, you have more than just judicial possible corruption, but financial corruption, and then you begin where, money was invested in Zuckerberg. And, of course, that probably lent credence, or at least suspicion, that people, judges, would be leaning, being part of the case, might have been taking money. One can't really prove it. And, of course, as he said, financial statements were not forthcoming from one of the judges. It just begins to wonder. Then one begins to wonder. Then you have the executive branch with executing a
executive order
by presidential privilege on this case. How can that be? But my greater question here is, outside of all the questions it brings up about how did this case proceed like this, and Zuckerberg still comes out smelling like a rose. Where does he go? Where do you go, Mike, when you've had your case reviewed all the way to the Supreme Court and you've had a review by the Supreme Court? Where can you go at this point?
Good question.
Well, that is a good question. Is it Annalise?
Yes.
Yes.
And one that I unfortunately can't really get into. But in general, the principle here is
well, the principle is intellectual property, which is sometimes really hard to prove. But there's so much corroborating evidence
we've proved that.
Your case. There's so much evidence.
We've proved the intellectual property.
I mean, yes, I'm saying exactly that. But at this
point,
so
what I was talking about was the justice system.
Yeah. Okay.
So when we find our justice system is
corrupt,
misconduct is occurring.
Well, yeah.
Nice way to put
corrupt.
It. Okay.
Then
the
question for all of us is, as citizens, what do we do?
Exactly.
And we are exploring that, and we are making plans. And I think that programs like Georgia's and others are going to have to bring it to the public, and maybe the public has got to get
involved.
But how would the public get involved? You can't really get involved in a court case, especially a court case which has a gag on it by presidential privilege. And furthermore, I don't know how the public would know how to override the Supreme Court. I mean, especially since you've already had it reviewed again.
Well, the Supreme Court denied the hearing, right, Mike?
That's right.
They did not review it. They
denied it.
Hear it.
Yeah. Mm-hmm.
But when they deny a rehearing of the case, I don't know where else you can go.
Well, that gets into the questions of what next, and what I don't want to reveal is what we're planning to do.
Can you please let us know later? That's my secondary statement. When this comes, would you please come back and tell us through Georgia let the other shoe drop so we know what's going on?
Well, let me suggest something that you can do.
All right.
What you can do is write your congressmen and your senators and ask for inquiries. Provide them the facts
of what? Of the case itself?
Of the conduct, because our public officials are supposed to be accountable. And when they exhibit misconduct, we have to ask that they be held accountable. Now, what that means now, I don't know exactly, but we have to keep asking the questions until we get some answers.
But what public officials do we go to, Mike? Where do we point that?
Your elected officials, your senators and congressmen.
Senators and congressmen. Are they part of this hearing? Are they privileged to this knowledge?
Well, they have a right to inquire and to conduct investigations.
I'm wondering even just the fact that when you heard about one of your reviews being turned down faster than your attorney did, there's something really wrong here.
Yeah.
Your attorney
I would say that numerous legal officials would agree with you.
I know that one. That's a no-brainer.
Yeah.
But how did that fly by?
Well, there's been you can't even count the number of things like that have occurred in this case. That's why we've got to start asking questions as a citizenry, because they took our property away from us.
And I think shedding light on this is the way to go, don't you think, Mike? We just have to get it out there. Yeah.
I appreciate you, Georgia, in doing this. And would you please bring this back?
Oh, absolutely.
If we get some answers here.
Oh, I was going to ask Mike at the end of the show to please follow up with me and keep me informed, because I'm very, very interested in the outcome of this, as we all should be.
As we all are.
Well, I imagine it's going to be a battle.
Yeah. All right, Annalise, thank you for your call, and we'll go out to Ron in Capitola. He also has a question. Yes, Ron.
Hi.
Hi.
Question for Mike. Mike, you're alleging that Zuckerberg hacked into your email and its attachment and basically stole your property. Isn't that, aside from the copyright issue, isn't that a criminal act in itself? And if you were to pursue that, did you prejudice your case specifically relating to that by pursuing the copyright?
Well, we pursued a patent case.
Yes,
we did not pursue other cases like trade secrets or copyrights or other things like that. So, I mean, you're asking a legal question, and I can't give you an answer to that. But the questions are on the table. We have other patents. We have other copyrights. So this is not the only bullet in our arsenal.
Well, what I'm saying, Mike, is aside from the copyright issue, isn't it an illegal act to hack into another person's email and steal property, not relating to the copyright?
I believe it is.
Yeah, and have you prejudiced your ability to pursue that issue legally by
going after the Mm-hmm.
Well, again, that's a legal question, and so I will kind of not comment on that. But what is obvious is that remember I mentioned earlier that the case was split, and so there are a lot of things that have not occurred yet in that case. Yeah. Because of the way the judge split off the damages trial, we couldn't tell that story at trial. Mark Zuckerberg's name did not come up at trial.
I see. Okay. One last comment. Relying on our representatives What a joke. Sam Parr, Nancy Pelosi. Right, Mike. I don't think so.
Well, I did. Sorry, I should have done my homework.
Yeah.
Yeah. And best of luck to you.
Thank you very much.
Thanks for the call, Ron. Okay, we will take a call from Ben in Santa Cruz, who also has a question. Welcome, Ben.
Hi. Yeah, this is a great subject. You know, I think the only court that you're going to really kick their butts in, and it'll be on an individual basis with the judges personally and then the financiers personally, is through the maritime courts and commercial liens. That's how everybody else seems to be going after these illegal funds that keep popping up everywhere. And as far as these illegal funds go, the money trail with this backdoor shenanigans with this $1 trillion, whatever billion dollars that keeps floating around everywhere, they're tying it all into just recently the banks in the Vatican banks were seized, and they discovered that there was a lot of politicians and judges from America, over 700, that had these slush funds, and they seized them. I don't know if they got the money, but they definitely shut them down so they couldn't utilize that money. And there's also another lawsuit going on in New York State where they're going after it's over the housing situation. It turns out this blob of money that helped finance Facebook is the same instrument or tool that's been used over and over in all these different money laundering schemes. And they're finding out that it comes from drug money, war profiteering, whatever was involved with this whole political shift in the Middle East in the last 20 years. It's all the same chunk of dough that keeps floating around and emerging in these weird ways. And it's ironic that all this new, every piece of technology that comes out that's some type of a people technology where people connect, that chunk of money mysteriously floats into the mix, and then they get the controlling interest of the stocks. And one last thing, Zuckerberg has a very weird mental, he's got this weird twist he's trying to put on everything, and he loves to play the psychological psyop. He was doing an interview on TV. It was late. It was like an afternoon TV show Friday night, and I forget what it was, something like Fox. And he came in with a black sweatshirt, like a hoodie on, and the person speaking to him, a woman, said, Mark, why don't you take off your sweater so you can get more comfortable? And so he took his sweater off and very carefully opened it up, and as he opened it up, he put it onto the chair, and he had this weird symbology on the inside of his sweater that was basically all that, you know, you hear about this Illuminati with the pyramid and the LCNI. And so he's trying to do this weird psyop where he's trying to show his, you know, followers that he's, like, connected, like he's in this inner core. And then as soon as everybody, and then as soon as the announcer started to call him on it, he very quickly rolled his sweater up and stuck it under the chair or put it on or whatever, and it was just this weird, creepy message that he was sending out to everybody.
Yeah, I saw that interview, Ben. Ben, but did you have a direct question for our guest?
Well, my question is kind of an answer. It's like you got to go after them in the maritime courts. This is how people are going after these individuals, because a lot of people don't realize our court system since 1933 had been usurped, and we're actually under admiralty law. A lot of people don't believe it. They don't want to believe it, but it's a fact. And the way that these individuals are being taken down financially is they're being, like, leaned on with commercial liens. And when you do a commercial lien, it basically shuts you down. You cannot. The only person that can take a commercial lien off, it ain't a judge. It's not a court. It's the actual individual himself, and it's through common law.
Well, Ben, thank you so much for the call.
Okay.
You sound like you're swimming in a tunnel here. I'm going to have to cut you off. But
Okay.
thanks for the call.
All
right. And I'm going to have to go to a quick commercial break. Neil and Freedom, hang on. And I've got some open lines, people, so call us. Welcome back, everybody. Thanks for staying tuned in here today. We are talking about the Leader versus Facebook case, and I'm going to go directly to Neil and see what Neil has to say. Hi, Neil.
Hi, I'm glad this is on the air, and I want people to know this is not one isolated case of one poor guy who happened to get shafted or fall through the cracks. We have a case, the Terminator case, And we had a federal judge rule that, yes, they had your material. He ruled, yes, they did have our material, but what they took wasn't protectable. And what this judge claimed was not protectable were scenes and music that their high-paid experts could find no prior art in all the history of music and literature. They could find no prior art matching what is in our story and in the Terminator story and in the music tracks. And he ruled it's just common stuff that's not protectable. So we went to the Ninth Circuit Court of Appeals, and the rules were a little confusing. We wound up being 300 and some words over. They dismissed the case, put a mandate on it that they would consider no reconsideration, no further motions could be made. They killed the case on the first technicality they could find. And these judges, I want to say publicly over the airwaves, their robes are filthy rags. They besmirch the name of honor, and they make a mockery of the sacred oath they took before God.
Wow. Mike.
So yours was a copyright case?
Copyright infringement. It was a first impression case. There was never a case before that involved story and music. Our comparison tapes, if you listen to them for a little while, you can't tell which is which. And the story, we've got whole scenes. I'll give you one quick. I'm not going to tell you my whole case. Don't worry. But for example, they in T4 they have the robots are controlled by a very subtle signal. That's in our story. It's discovered. They capture a robot, as in our story. They disconnect the receiver, as in our story. They turn the receiver around and try to use it against the other side, but it doesn't work out. All that's in our story. Not in any other work in all of history. But those are just common scenes of fare, according to this judge, that they're not protectable, and a lot of stuff like that. The whole sky.
Well, one of the things I have seen is that when courts want to use procedure as a weapon, they do, and when they want to use procedure as an excuse, they do. So procedure is a great tool for. It should be. If you read the rules as they're written, they're very fair. If they're not applied fairly, they become a weapon.
Yeah, our courts are wonderful, but when you get when you get vermin involved, dishonest, disloyal, un-American punks with robes and credentials, they ruin everything because freedom rests upon justice. And I also have reason to believe that my computer was hacked. And they didn't just hack your email. They probably went into all your files. They have the ability to do it because there's some other things that happened that only could have been gotten by the same people, could only have come out of my secret computer files, things I hadn't shown yet, that I announced in my papers that I wouldn't show some new things that were better than the Terminator because I was afraid until I see there's justice. And next thing I know, there's a new movie out with my story again.
Oh, my gosh.
Too much, Avatar. Yeah, Avatar has many of the elements of my Yaya story that's in my computer files. So I wrote to the FBI and told them about it and told them about the new work I have that's also in my computer, and that I would not be surprised if James Cameron came out with another movie about my other story, which I gave them a synopsis of. So I took a shot in the dark and wrote to the FBI about it and asked them to please look into it, and I have not received a rejection from them. So I'm hoping there'll be just an amazing jaw-dropping occurrence when they catch this huge but common thief named James Cameron.
Well, I hope that they do, Neil, and thank you so much for sharing that story. Mike, did you want to make any comment to Neil before we let him go?
Well, one of the things about invention is invention is hard and copying is easy.
Oh, yeah, people think it's nothing, but, writers sit up all through the middle of the night. It's like giving birth, it's painful and it's hard, and finally that thing that's there comes
bubbling up.
The Founding Fathers saw that as such an important quality that they embedded the copyright and patent property right in the Constitution of the United States. It's the only property right in the Constitution.
And you know how they knew that? Because the Constitution itself comes from that higher realm where that amazing stuff comes pouring through. If you try hard enough and wait long enough, it finally, the barriers of the mind break down and the genius comes through that isn't even yours. You know what I'm talking about. So when that is stolen, that is a big thing. That is a really big thing. When someone thinks they can just take it and they say, here, go for 10 years, which it's been. But I still... This Terminator case is not over yet. because I took it to the highest court, and I expect something amazing to happen, and I'm glad I got to say it publicly.
Well, Neil, good luck to you, Neil. And why don't you keep us apprised of what happens to you with this case? Would you do that? I think Neil is gone. So I'm going to go out to Dan in Aptos. Dan, you have a question.
Yes, first of all, I want to thank you, Georgia, and Mike for bringing this up to the listeners for exposing this travesty of justice.
Mm-hmm.
One thing I wanted to ask Mike about and see if he could give us some more background on this. As we all know, after the IPO of Facebook last year, it appeared that it was the classic pump and dump scheme. And as a frequent visitor to the Americans for Innovation website, I've noticed that it looked like the SEC appeared to give Facebook a very wide latitude when they filed their S-1 for that IPO. And, you know, it showed that they could allow anything to be eliminated from this very important document, and a very glaring thing that was not there was this case of Leader v. Facebook. Mm-hmm. And Mike, could you give us a little background on that?
Well, I got the S1 like everybody else did. I can't remember what the date was, early last year. And the first thing that just stood out like a sore thumb was the lead counsel on the Facebook case was my former corporate counsel in 2002, 2003, Fenwick and West.
Mm.
And Gordon Davidson specifically, who was the first attorney there that I'd interviewed before we selected them as our attorneys. And that obviously was a red flag. And then we started digging into the disclosure, and we're just appalled that somebody who was our former corporate counsel would represent somebody who was an active litigant against us. And of course, law firms have many ways to explain that, and I'm sure they feel quite justified. But
they knew everything about you then, Mike, didn't they? Your financials, your technical. Didn't that group know everything about you, having represented you?
Of course they did.
Yeah.
And they had our source code in their files.
Oh my gosh.
Unbelievable.
Unbelievable is the word.
Mm.
Oh.
So then you dig a little bit more, and you find out that Fenwick and West is a lead patent filer for Mark Zuckerberg and Facebook. So here we've got my former corporate counsel filing patents for Facebook, and in the process of filing those patents, didn't disclose to the patent office that our technology existed out there as prior art. So the questions just keep piling up.
The deeper you dig, the more interesting this case becomes.
Right.
And so that should invalidate any patents that Facebook ever hopes to have in the future, correct?
Well, I mean, those are legal determinations, so I can't say whether they would or they wouldn't. The rule is that if you know that there's potential prior art that could invalidate your patent if the examiner knew about it, and you choose not to disclose it to the examiner, that's called in the law inequitable conduct. And that's another way of saying fraud, because you're intentionally withholding that information. So if that occurs, and if that is proven to be true, yeah, it could invalidate your patents that you're filing.
Mm-hmm. Wow.
Dan, are you as shocked as I am that this didn't get played everywhere and isn't on the airwaves?
Well, I am. Another thing that really shocks me is that the SEC did not require Facebook to have in that S1 that this very important litigation was going on, when they were getting their things in order for this IPO.
Yeah, because
this was a very material fact for investors who were looking at investing in Facebook.
Mm-hmm.
And I just can't imagine how the SEC let this slide.
or that 2 of the 3 judges on our panel held Facebook stock through their investments.
Well, that's right too. So anyway, I should let somebody else, comment. But thank you so much, Mike. I really appreciate it.
Thanks, Dan. Mm-hmm. Okay, Sam, my engineer, has a question.
Mike, Sam Quinton here. I was curious, when the Supreme Court decides to not hear your case, is it possible to ask them a second time if they will? Or is that the end of that process?
I believe that's possible, but it's so rarely.
There's no percentage in it, huh?
It's so rarely granted that I think a lot of law firms don't do it. But I'm not sure. I think that I've read that.
Yeah. Anything else, Sam?
Well, no.
Quite a story, isn't it?
This is just overwhelming.
It is overwhelming.
The level and depth of the corruption going on here, it's astounding.
Yeah, we should all be afraid, very afraid.
Yeah.
As citizens of this country. I don't know what's happening to us here, but something's gone way awry.
Well, Mike, all I can say is fight the good fight and keep going.
Yeah.
Will do.
Well, we're going to take our last commercial break. We do have open lines, so here's your opportunity, folks. We'll be right back. Welcome back, everybody. You've been listening to KSCO Presents with Georgia, and I have been fortunate today to have Mike McKibben as my guest. You have been listening to, I think, an amazing story. Our phone lines are open, 831-479-1080. Mike, is there anything you want to leave us with? Or is there anything we didn't cover that you would like to bring out at this point before we let you go?
Yeah, I think that the question of what's in it for the listeners, I think it's about property rights.
Yes.
And the two property rights in this country, privacy and the right to property, have been bedrock issues in our democracy as checks against an all-powerful state, which our founding fathers had reacted to from Europe. And so the issue of privacy, the issue of property, kept the power of the state from encroaching on people's individual lives and liberty. And what we have experienced is a situation where the courts, on the one hand, they said, Facebook is literally infringing leaders' technology, but on the other hand, they're saying it doesn't matter, and oh, by the way, we're not going to use the tests that we normally use where we're turning a blind eye. We're just going to turn a blind eye, and we're going to give Facebook what they want, which is in a sense the power of the state coming in and saying, okay, we want your property because our friend here wants it. And that's disturbing. That's got to be disturbing for anybody, and whether it's real property or intellectual property. When the state starts doing that and not protecting these deeds, these patents, these copyrights, then our democracy is at risk.
That's exactly it. Beautifully said. So we have to keep up the fight. We have to get the word out. And I guess pray and hope for the best, Mike. I would appreciate that every one of your listeners would try to figure out what they could do, because and use our case as their action, because this is right before us now, and the issues are on the table. And I can say that there are a number of people in Congress and in the Senate that are aware of this. So the more noise we make, the more likely it is that we can get some constructive things done here. Your Congressman Jim Jordan is one of those men, isn't he?
There are several congressmen. He is one. He's not actually in our district, but he is in Ohio.
And he is also the man who's pursuing the Benghazi situation. So we have great respect for people like that. We're lucky that
he's on Congressman Issa's committee, the House Oversight Committee for government reform.
Hey, Mike, one last question. So you think that we should contact our congressmen and senators, ask them to look into this matter? What frightens me is how many of them also have stock in Facebook?
Well, ask them.
And they're going to tell us?
Well,
see, I don't think they're going to do that.
Yeah.
You have a right to ask, and I think that the key here is that we need to make noise. If our elected officials and those that we pay in the bureaucracy to do their job are not doing their job, then it's our citizens' duty to speak up, to speak out, and demand accountability until we see it. And until we see it, we keep talking. We keep saying, "Hey, you've got to do something." With the Senate and House inquiries, the senators and congressmen are supposed to inquire into your questions.
Yeah, because they're supposed to be representing us, but it doesn't work that way.
But lately I have been flooding John McCain and Lindsey Graham and Feinstein and all of these people. I have been calling and leaving my thoughts weekly, and I encourage everybody to do it. Don't do it one time. Follow up. Keep getting it out there. If enough people call and continue to talk about something, it will get some attention.
Yes.
All right, so we've got a caller here from Seascape. Lee, hi. Welcome to KSCO, Lee.
Well, hi, Georgia. Thanks.
Mm-hmm.
Hey, I looked up Americans for Innovation, and that's a really great site for someone who's interested in this travesty to go to find more information. And for the listeners, it's Americans for, the number 4, innovation.blogspot.com.
Repeat that, would you?
Okay, it's Americans, so it's just Americans, the number 4, innovation, that's all one word, .blogspot.com.
Okay.
Just a wealth of information that will give the listeners an incredible background on this whole story.
Okay, thank you for that information. We appreciate it.
Okay.
Thank you.
Mike, is there any other websites that our listeners who have been piqued today by their curiosity, piqued by this case, is there any other websites that you would direct them to learn more about
I would say if you go to Google and just type leader and then the letter V, Facebook, it will point to a number of different sites that are carrying information.
Okay.
That's probably the easiest way.
Okay. So I hope that that's what occurs. Now, anything else, Mike? Anything else you wanted to add?
I really appreciate you bringing up these facts, and our task is to get the facts out. And for those of us in America who still believe in the rule of law, we need to insist on accountability in our justice system.
I agree, Mike. And I just want to thank you for being here today with this extraordinary story. Among a people generally corrupt, liberty cannot long exist. I wish you Godspeed, and I hope you will stay in touch and let us know how this case plays out, Mike.
I will, Georgia, and thank you for having me on.
Thank you so much, and good luck.
Thank you.
We'll talk again.
Okay, bye-bye.
Bye-bye. Okay, so there you have it, folks. That was our guest. We're almost getting to the end of our hour. Any thoughts from you, Sam? It's kind of overwhelming, isn't it?
Yes, it is, because what the heck can you do?
Yeah, it's a feeling of hopelessness and helplessness.
You get the high, hard one from people of power.
Yeah.
And it's because of their own personal greed and involvement with Facebook. They want to make some money. And they don't want anybody to know they're doing it.
Yeah.
And they will actually railroad somebody else's patent after it was stolen in the first place by that little weasel Zuckerberg. And nobody can do anything about it.
Yeah. And the incestuous involvement of all the players and the global connection to the monies that are, going out to other countries related to the case is very disturbing to those of us who believe there's some kind of a global takeover going on here. That's also disturbing.
Yes.
Because it feels so big.
The one world thing.
Yeah,
and,
it really
which,
is.
Obama would like to be the king.
The king of, yeah. And even his involvement even his involvement as our president is very disturbing to me. It seems to me this man can do what he wants and get away with it.
Complete impunity, and the lapdog media won't go near any of this stuff.
You know, last night he was entertaining in the White House with all the big mucky mucks from Hollywood again, and yet the White House was closed to we the people. And yet nobody's saying, why is this happening? And he's not even embarrassed or ashamed about it, Sam. He just does it blatantly.
No, he'll do whatever he wants.
He surely does.
Carte blanche. And I want to go back to this one more time. You know, you say that you contact Dianne Feinstein.
I do.
And every week.
I leave messages.
And how's it going? How's that working out? Because you know what worries me is that if we are calling our congressmen and senators and asking them to investigate this situation, I don't have any confidence whatsoever they're going to represent we the people in that endeavor.
Well, but we have to do something, Sam. And at least it gets it off my chest. At least I feel like I'm doing something rather than doing absolutely nothing.
Tune in to Georgia Wednesdays on KSCO Presents from 12 to 2 for the freshest conservative voice to come along in years. Born and raised in South Carolina, Georgia has a sweet southern charm backed up with the tenacity of a junkyard dog as she speaks her mind about the direction of our country and the elected leaders' response.